thing about Juan Gold. He's not a troll. He's a well thought out, and most of his responses are well thought out.
Well, thanks, Mark. You've just explained why my motions, briefs, and litigation skills have been successful all the way to the U.S. Supreme Court. Hey, talking about success, let's revisit one of Stephen's claims of success. He was very excited about the dismissal, as he should have been. Stevens presents the order dismissing the case after a conviction in magistrate court and again in the appeal to the circuit court. Stevens had them file multiple motions: motions to strike complaint, motion for disqualification, motion to dismiss for prosecutorial misconduct, motion to dismiss for conflict of interest, and motion in limine.
These are great. I want to thank Gadsden Viper for calling in to the last radio show. I will get that linked into the article that's on markstevens.net. Called in the middle of a show to relate to me another motion to dismiss that was granted. This time the charges were dismissed with prejudice, which is significant. We'll go through that. So a big thanks for him for calling into the show, and then also really big thanks for sending me the documentary proof, because there's one thing that drives this radio show, and it's proof. We don't make claims that, well, I'm special, I'm a special little snowflake, and my claims are true because I say so. No, we reject logical fallacies just as much as we reject the concept of, or the actual, violent ruling class here. We don't accept that, but I do appreciate him sending me the proof. We'll show it here. Boom, there it is, dismissed with prejudice. Now, this is significant for a number of reasons, so I want to go through this because we're also going to address some of the stupid things that we hear critics say. Just the stupidest things. But keep in mind, the only reason why they are making the criticisms that they are is not because my work doesn't have merit. It damn well does. There's a mountain of evidence to prove this, and this is just the latest. They just cannot admit that there's any merit because they know it's true. They can't find any flaw in the logic. They can't find any flaw in the evidence. They don't like the ultimate conclusion that their sacred rules that they think apply to everybody don't. Alright, so as he reported on the show, there was a trial. No evidence was produced to prove that just because he was physically in West Virginia that the Constitution and Code applied. Actually, it was to his wife, but it's kind of not important. There was also no witness for personal first-hand knowledge that just because she was physically in West Virginia, the Constitution and Code applied. And that is necessary because you have to have a witness for personal first-hand knowledge. If the cop is going to testify that you violated the law, he has to be able to testify and have personal knowledge that the laws apply in the first place. But they like to assume. This is an element of the charges we'll get to. So of course it was a sham trial. There was a judgment of guilty, so they had contacted me and they filed a motion to dismiss, well, basically a motion to vacate the judgment.
Okay, as you've heard, Stevens promotes this dismissal as proof his motions have merit and logic. Well, okay, let's see if this is true or a lie by further investigation of Stevens' claim. Now, the next video clip is from another pseudo-lawyer / philosopher who uses Stevens' motions and arguments. He overly editorializes, so I've edited out his ramblings. However, I have provided a link to the full video in the description below.
This message is for Judge Jacob Rieger of Lewis County, West Virginia. My name is not important. I am anonymous. I am working on a case that you have terrorized, let's say, a associate of mine with. And so I've been put on the job, and we're going to expose your nonsense here. And we're going to do it in a real funny way, a real public way. And I'm going to make a series of videos about this. So, Judge Rieger, mwah, kisses. This one's for you, alright? Here we go. My friend is a husband. His wife got a traffic ticket for speeding, slight speeding, nothing dangerous, and failure to produce a driver's license. He fought this, they fought this, and they got a dismissal, right? Earlier this year. In October, the court came back and the judge said, "Oh, my mistake. I thought I was dismissing an appeal, motion for an appeal, not the entire case altogether. Oops, my bad. Therefore, I'm going to..." Hilarious. Therefore, I'm going to fix that mistake and take back that dismissal of that motion to appeal, which turned out to be a motion to dismiss the entire case, all charges. And instead, I'm going to reinstate the... I'm going to pretend that never happened and change it so that it was guilty from the trial instead of dismissed. And they're going to be fined $300 plus court costs for those two combined tickets. So keep in mind, that's what started all this. Nothing huge, petty misdemeanor stuff, right? Only a couple $100, right? And I'm going to go listen to the original arraignment. I'm going to go listen to the original trial. I'm going to be pulling out appealable errors. I'm then going to be writing them up in a document, handing them to my associate, my buddy, and he is going to appeal this with the Supreme Court in West Virginia. So Jacob Rieger, or however the hell you pronounce your last name, this one's for you. It's going on YouTube and it's public. It's one of my first, and I want to use it as a kind of a demonstration for how I could potentially help people help themselves or just help them outright in the future. Let's see how this goes. So here's the order, clarifying an order of the decision of the trial. I hope that brings everybody up to speed. Dated January 11, 2017. All right. On the 11th day of January, this is what that judge writes to justify his reversal. 2017, the court was informed that the defendant wished to dismiss her appeal. Now keep in mind, all these tickets are against his wife. The court granted the defendant's request to dismiss her petition for appeal. So he's continuing. However, the order prepared by the defendant, so we prepare our own orders so that the judge just has to sign it, right? And there's nothing tricky about it. It's at the end of the motion to dismiss. This is the standard stuff that Marc Stevens uses that we get from markstevens.net. Marc with a C. This is the standard stuff. Everyone across the country has used it, and in other countries too. I've never seen this problem happen before. This is the first time I've ever seen this problem. This is the first time I've seen a judge reverse their own decision based on BS, and that leading to an appeal to the state Supreme Court. That's what we're appealing to. All over what? A traffic ticket of minor speeding and failure to show a driver's license, or as they call it, an operator's license, right? All right. Enough of the background. I'm just going to try to get through this order without too much further commentary. Here we go. All right. So the court granted the defendant's request to dismiss her petition for appeal. However, the order prepared by the defendant dismissed the case with prejudice. Of course, simple English, that's what it is. So, wherefore, it has become necessary to clarify that the court's order on the defendant's request to dismiss her petition for appeal, that's a lie, did not dismiss her appeal. Instead, the order inadvertently dismissed the case against the defendant. The court was awaiting a proposed order from the Lewis County Prosecuting Attorney's Office regarding the March 4th, 2016 bench trial. Now that's 2 months later, after the 11th of January, obviously, in which the court found the defendant guilty of both speeding and operating a motor vehicle without an operator's license. Okay. So he's now blamed. In the interim, the defendant moved for a dismissal of her appeal. Now that the court determined either dismissing the appeal or entering a trial order would have the same effect. All right. Was to utilize the defendant's proposed order, granting what the defendant referred to as a motion to dismiss, quotes, the magistrate court conviction would stand due to the defendant dismissing / withdrawing her petition for appeal. I don't get it. Thereupon, the court will not consider the defendant's motion to dismiss the appeal and will enter a separate order from the defendant's bench trial of March 4th, 2016. So they're saying, oh, we're going to just erase that we did that, and we're going to go back and do our own trial entry, right? Wherefore, for the reasons set forth above, the court hereby orders that the order from January 11th, 2017 is hereby declared null and void. That's a haha, how about that? The Lewis County Circuit Clerk this happened in circuit court, not district, is hereby directed to send a copy of this order to all parties of interest. This was entered on the 19th day of October. And they gave him like 30 days to respond, 30 days to appeal to the Supreme Court. All right, hence that's what we're up to.
Whoa! Stephen's motion to dismiss was granted by what amounts to a clerical error. It had nothing to do with his merits and his logic. Oh, goodness. Now, here's a copy of the clarifying order that you can read for yourself. Now, here's the order from the bench trial that reflects what happened during the trial and the findings of the court, and which replaces the erroneous dismissal.
All right, before we begin with the trial itself, here is the order Judge Jacob Rieger entered, the order from the bench trial. So he replaced the dismissal with this order from the bench trial in March, right? And this is their account of what happened. Like, read, this is insane. All right, here we go. This is bananas. On the 4th day of May, oh, this is May when they had the trial, 2016, the above captioned case came on for a bench trial pursuant to amended order entered on the 2nd day of May. See how this is all fallen into place? So amended order, 2nd day of May, was probably a pre-trial hearing. Are you ready? Are you ready? Oh, you're not ready? Oh, too bad. You're going to come here in 2 days and have a trial. That's how it went down. In accordance with West Virginia Code 50-5-13B, right? All right. Whereupon the following parties were present: the state of Virginia by Kurt W. Hall, assistant prosecuting attorney, and the wife of my friend, who they say is appearing in person pro se. So we're going to be challenging that. They want her to be pro se. Whereupon the court asked if the parties were ready to proceed. Are you ready? This is American justice, quote unquote. Thereupon the court directed a non-attorney seated at defense counsel table to sit in the gallery. Thereupon both the state and defendant indicated they were ready to proceed. Really? Thereupon the defendant sought to enter a plea of guilty. Thereupon the defendant began asking the court numerous questions under the pretext of point of clarification. Well, thereupon the court answered several, quote-unquote, point of clarification questions. See, until such questioning became inappropriate. The court will address the pro se status of the defendant. There's no defendant in it whatsoever. Keep your words to yourself and your opinions as well. In this action, quote, when a litigant chooses to represent himself, well, it's a herself, it is the duty of the trial court, Judge Rieger, to ensure, is that how you spell ensure in that context? I think it's E-N. Oh, I hope I'm right. I'm calling out his spelling. Ensure fairness, allowing reasonable accommodations for the pro se litigant. We're not pro se, we're not litigants, so long as no harm is done an adverse party. More importantly, the trial court must strive to ensure that no person's cause or defense is defeated solely by reason of their unfamiliarity with procedural or evidentiary rules. Quote, at the same time, the Supreme Court of Appeals of West Virginia has also recognized that, and that's his bracketed, it's not what he's directly pulling it off of, so I'd have to look that up, has also recognized that a court must not overlook the rules to the prejudice of any party. What a Hippocratic lie. The court should strive, however, to ensure that the diligent pro se party does not forfeit any substantial rights by inadvertent omission or mistake. That never happened. Cases should be decided on the merits, and to that end, justice is served by reasonably accommodating all parties, whether represented by counsel or not. Quote, reasonable accommodation does not, however, require a court to cross the fine line between accommodating a litigant and advocating for the litigant. They cross that all the time. Nor does it require the court to give legal counsel. They flirt with that line all the time. Ultimately, the pro se litigant, we are not that, bears the responsibility and the consequences of his mistakes and errors. Lord. The quote-unquote point of clarification questions being asked by the defendant crossed the line from being reasonable accommodations to being paramount to legal advice. Thereupon, the court advised the defendant that the defendant could enter a plea of guilty or proceed with the previously scheduled bench trial, which the defendant objected to moving forward without completing her list of points of clarification. Well, there you go. Completing a list Well, just trying to clarify your own rules. The court denied the defendant's objection. Whereupon the court heard arguments regarding the pending motion to strike complaint, motion for disqualification of the judge for obvious reasons, motion to dismiss for prosecutorial misconduct for obvious reasons to the prosecutor, motion to dismiss for conflict of interest for obvious reasons because motion to dismiss for conflict of interest, and motion in limine. These motions were put in. Motion to strike is to dismiss the entire thing, the whole complaint, all charges and everything. Thereupon said motions were denied for the reasons set forth upon the record. The court proceeded to bench trial. That's a trial with no jury possibility and a bench. And these charges have max jail time of 30 days. They could, if they wanted to, send you to jail for 30 days, and there's nothing you could do about it. Thereupon the state proceeded to its case in chief by calling oh, that's a nice last name for a sheriff, with the Lewis County Sheriff's Department, and then rested. Whereupon the defendant chose not to testify in the matter and had no witnesses to call. Why would you? Before this country celebrates its 250th birthday. Thereupon the court, after considering the evidence and hearing the arguments of the state and defendant, finds the defendant guilty of the offense of speeding in violation of code blah blah blah, even though we're not even going to answer their challenge to said code, we're just going to enforce it anyway, and the offense of driving a vehicle without an operator's license. Please look up what. Whereupon the court sentenced the defendant to a fine in the amount of $50 and on the speeding charge, plus court costs, and a fine in the amount of $250 on the driving a vehicle without an operator's license, plus court costs. So, 19th day of October 2017. Beth Burkhart is the clerk. Jacob Rieger is the circuit court judge.
Well, as you heard, they're going to appeal. The appeals court will review Stevens' motions. And Stevens has told us that his motions have merit and flawless logic, and he challenged people to prove his motions lack merit and logic. Well, we're in luck. The appeal was decided October 19th, 2018, and Stevens' motions are addressed and dissected in the order of the appeals court. So stay tuned. A video fully showing the results of the appeal is coming soon.